Lord, after going through, my lord, the facts which we will point out on this side, your lordships would be satisfied that large number of fundamental rights and other rights will be now conferred upon the residents of Jammu and Kashmir, and they would be fully at par with rest of their brothers and sisters of this country.
Yes.
But number two,
Yes.
because of the ongoing confusion, which according to us there was none, but because of the ongoing confusion whether this provision is temporary or it has become permanent, etc., there was a psychological duality amongst the minds of the residents of Jammu and Kashmir, and that was being taken disadvantage of by, I would say, my lord, interests not inimical to India. That would be settled once and for all, whichever way your lordship decides.
Yes.
Now, my lord, I'll take your lordship. My lord, I must, my lord, assure your lordships that yesterday we undertook an exercise that your lordships have been appraised with almost everything, my lord, on facts. But your lordships are specifically not appraised with many things. So this is only for one reason, my lord, I am reading this part. My Lord Justice Gawai was pleased to put a question. There was a Praja Sabha constituted, your lordships would recall. And my Lord's question was, what was the composition of the Praja Sabha? No, that is what is mentioned. Just, my Lord, taking your lordships chronologically, your lordships have seen this provision as well. I am just, my Lord, refreshing your lordships' memory without reading the provision. Lord, this is a part of Government of India Act 1935. My Lord, the purpose of showing this is to, my Lord, point out to your lordships, and ultimately I'll assist your lordship with that proposition and one or two judgments on this. The moment the accession is complete, the sovereignty gets lost. The sovereignty is subsumed with the bigger sovereign.
Actually, Mr. Solicitor, you may also read Section 5.
Yes.
Because what is the importance of accession? That Section 5(1) gives us.
Yes. Not the smaller regions, which eventually.
The consequence of an accession under the Government of India Act was that then the acceding, they would be united in a federation.
The federation.
The key words really in 5 are united in a federation.
In a federation. So, my lord, that is the first stage of losing sovereignty. The moment you sign accession and it is accepted.
But you'll have to at some stage deal with the argument which they have urged that sovereignty itself has an external component and an internal component. External component was lost, internal sovereignty still remained. That's the
argument, my lord. We are conscious of that. And, my lord, I'll also bear in mind your lordship's very, very pertinent observation that ends may not justify the means. I'll also show to your lordships the means adopted strictly within the constitutional parameters and as per various judgments of your lordship. But that's, my lord, after, my lord, the factual chronology. But this is also crucial. We were, as British India also, our leaders were already negotiating that princely states should also come at par with the provinces, British provinces, which were already under the suzerainty or sovereignty, as the case may be, of the British. Then, my lord, 7th September 1939, Jammu and Kashmir Constitution Act 1939 was issued by Raja Hari Singh. It established a council with a prime minister. Why, my lord, I'm reading this, my lord, I'll just paraphrase this argument. Lord, why I say this? Lord, substantial arguments, my lord, were made that there were no constitutions. Jammu and Kashmir had a special place in the geographical British India because that was the only part which had its own constitution in 39. But that is factually incorrect. There were 62 states which had their own constitutions, whether they are named as constitution or any instrument of governance, internal governance. I'm just trying to show that the argument that Jammu and Kashmir had a special status from the beginning, which continued till date, is factually wrong. The foundation is wrong. And 286 states were in the process of framing that constitution during this period of late 40s, late 30s, 39 onwards. As a matter of fact, the eminent councils of the day, those days, were, my lord, engaged to help the princely states to draw their constitutions. I'm not going into that detail, that's not relevant, but one of the, my lord, when we researched this, Alladi Krishnaswamy Iyer, who was considered to be one of the top ranking councils, was engaged. His fees were not found to be, the problem was there at that time also. By one state called Rewa in present Uttar Pradesh, I'm sorry, Madhya Pradesh. And therefore, my lord, he was requested not to continue because it was found to be too exorbitant.
For J&K, the constitution decided to go to 370. The other states, there was no provision like 370. They merged and they were integrated completely. They accepted list 1, they accepted list 3, they accepted the ultimate dominion powers, executive and legislature of the Dominion of India.
I'm just showing this with a view to make one point, that a stand which is now being taken and which has been taken, that we had a special feature and therefore we were given a special treatment, and therefore this provision is kind of a privilege given to us which can never be taken away. But I'm just trying to show that there were many similarly situated princely states. They had also put their conditions, but eventually they subsumed themselves with the Union of India because of the Act of State doctrine and because of Article 363 and Article 1. But
they came into the Indian Union as a volition. They joined voluntarily. I mean, we take it as voluntarily. It may have been a little bit of persuasion. It may have been whatever. Real politics. Yes, obviously.
Are made.
Obviously, no difficulty. And that was probably the genius of Sardar Patel. There's no difficulty. There's no doubt about it. But the fact, however, remains that insofar as J&K is concerned, J&K bucked that trend. J&K went to the 370 route.
Yes, but why, how, and till what time? Right. That will come, my lord, subsequent. And that's why, my lord, for me, as I said, my lord, in the outset, connecting the dots would be necessary.
So the limited point which you are making at this stage is that the instruments of accession of various princely states contain certain reservations. Now we have seen in regard to taxation, in regard to land acquisition,
binding constitution.
Not binding themselves to accepting a future constitution. So the IOAs at that point of these states were hedged with various conditions.
This is also.
But that was consistent with Section 6 of the Government of India Act, which was adopted by Section 9 of the Indian Independence Act. We gave this sop to the princely rulers that, look, you come here on your terms. We are not telling you today to come on our terms. You agree to the Indian Union, you make reservations, and we hope that by and by you will accept full integration into the Union, which they did.
Another point why I wish your lordships made aware of this development is, there was an argument that instrument of merger was a necessary attribute for a complete integration. Otherwise, we had kind of an internal sovereignty. Your lordships would recall that Jammu and Kashmir never signed instrument of merger. Many states did not sign instrument of merger. From the date on which Constitution of India came into force and Article 1 came into force as an act of the state, they became integral part of Union of India. And how Jammu and Kashmir got separated, my lord, and how it was only for a temporary period, but would succinctly come, my lord, in subsequent.
Interesting, Mr. Solicitor, this Department of States which existed in the Ministry of Home Affairs post 1950, after the 7th Amendment, right, 1956.
238 was, yes.
So the Department of States must have been abolished post 1956. You will be still having records in the Ministry of Home Affairs?
I'm sorry, my lord, my instructions are, the officer sitting, my lord, was the additional secretary in charge of Jammu Kashmir in MHA. He said that department technically still continues.
So Department of State still continues?
Still continues.
Now, do we have, I'm not sure whether this exercise can be done just for, I mean, you don't have to do it by a very detailed document, but just a tabulation. If we can have a list of the states and, we can have, say, Kathiawar, instrument of accession, supplementary instrument of accession, and merger agreement. Which of the states came into the union with a merger agreement? Which of the states had no merger agreement at all and yet joined the union? I don't know whether that now at this point of time that record will be there. If you can try and record, if you can sort of.
To a large extent, white paper indicates what happened.
I don't know if you have that record. I mean, how many out of these 562 who actually joined the Union of India actually executed merger agreements?
No, what happened?
What I meant was, how many of these states which joined the Union of India did not execute merger agreements? That will be a smaller group probably.
But possibly.
So, which will then perhaps give some support to your argument that the execution of a merger agreement was not quintessential to acceptance of ultimate sovereignty by India. And second, many states, many princely states, were subsumed with the Union of India even without a merger agreement. And various states, therefore, were subsumed in the Union of India only with an instrument of accession.
We'll do that exercise. Substantially, everything is there in the white paper. But if there is something else also, Manoj.
All 562 states, not India. What happened? No, there were small little principalities, small nawabs. They got
They were
larger.
We were just, in fact, Brother Suryakant was giving us a little bit of backdrop about Punjab and Himachal.
To integration with larger states. And then the larger one signed the instrument of merger.
Right, but we were wondering, was it possible? Because, Mr. Sibal, what we want a little bit of just factual...
I have understood,
factual clarity, that they may have, were there Indian states, we shouldn't call them princely states, because as Mr. Sibal says, some of the small Nawab, some the princes.
We will have to say princely states, because Indian state would mean those which were under the sovereignty or suzerainty of British India. That's how it has.
They were the governor's provinces.
That's right.
No, but we just want to know this.
We will not undertake.
To sort of repeat two things. Which were the states which accepted completely to be subsumed within the Union of India without merger agreements, and followed only the IOA course and straight came into the Union of India?
There is no such instance, but with respect to the white paper, which is part of the record. White paper is issued by Sardar Patel.
I will not formulate it. I have understood the question. Let me not.
You know, Mr. Shankar, I just thought since the Department of States exists even today, this is something they might take a day or 2 days, but they will be able to do it.
It would be done.
The table here with the states which have not entered into a merger. It's helping your point. Actually, if you want a list of states which have
What is the source of your table?
It's from the white paper.
White paper. There are inaccuracies. I'll put it that way.
So there are states which did not accept the merger and yet became a part of the Indian Union.
State of Mysore, state of Saurashtra pre-independence, Madhya Bharat, Patiala and East Punjab.
This is
part from the white paper. There is a chart.
We will not. Let's not deviate from it. I have taken the point.
Your point is that there were other states, basically whether it was 2, 3, 4, 5, whatever. There were other states which did not sign the merger agreement.
Yes, there was nothing special which is being claimed.
That's your point.
And second, that merger was such a sine qua non, without which you can never be an integral part of India, either under Article 1 or otherwise, or your special status must continue.